Please, so there's a quick one. The council to the federal government has. I don't, especially when they said that releasing him will cause
national security
situation in the southeast. All you have to tell about that,
yeah,
and just generally what happened.
They cited the case of Asari Dokubo, which is not relevant, which was an application to enforce his fundamental rights. And the federal government said the right of one individual cannot override state security. This is not the case here. This Court of Appeal has already found that the lower court was wrong in retaining 7 out of the 15-count charge. And so this court also dismissed the remaining 7 counts and said Nnamdi Kanu is discharged. Discharge means you have no case against you. A very responsible government, all they will do is to let that young man go home, particularly as we have shown in our affidavit evidence and documents that is gravely ill, has a heart condition, which a specialist doctor has said needs an urgent surgery. And they have no answer to his medical conditions. All they are doing, when they feel that his potassium level is too high, they either increase the dosage or decrease it. So they are just using Nnamdi Kanu as a guinea pig, trial by error. So we responded that there is no question of saying releasing Nnamdi Kanu will bring unrest in the southeast. As a matter of fact, it is the release of Nnamdi Kanu that will bring about peace and tranquility, not only in the southeast, but in the entire country. And I gave the court the example. When the court made its judgment or pronounced its judgment on the 13th of this month, the entire southeast went wide with jubilation. They were drinking, eating, dining, and dancing on the streets for the next 3 days, 4 days, 5 days, from Owerri to Aba, from Umuahia to Enugu, from Onitsha to Abagana, from Umuchu, Ekulobia, Amesi, Uga to Njukoka, from Abakaliki to Enugu, from Port Harcourt to Aba, everywhere. The Igbos are happy and they are looking forward to this judgment that once Nnamdi Kanu is released, there will be peace in the southeast. 2023 elections will come very well. I thought, I do not know who advises this government. If I were their advisor, I would say, sir, Mr. President, let my people go. And with Nnamdi Kanu leaving prisons, don't forget, any day they hold him further from 13th of October is illegal detention. We are already going to court with a fundamental rights enforcement matter. So it is releasing Nnamdi Kanu that will bring about peace and tranquility, not detaining him. And we have also argued that the court cannot stay the liberty of a citizen. That was why we cited the case of Gloria Mowari versus Nigerian Army. Ulisagbakoba SA, my good friend, handled that matter. I was detained with Ulisagbakoba over that coup of April 1990. We were detained at Child Avenue by the DMI in Apapa, near a toilet, with soakaways, with maggots and human feces coming out so as to punish us. And in that case, Gloria Mowari was 7 months pregnant. She miscarried because of the traumatic the ordeal, psychological, mental, physical that she went through. And when they went to court, the court said they should release her because she was discharged, just as Nnamdi Kanu was discharged here. What did they do? The federal government filed an appeal in that case against a woman who was detained under decree number 2, under IBB, when the military was the military. And they also filed a motion for stay of execution two justices' pronouncements were very hard on the federal government. Justice Atu Kalgo, who later was elevated to the Supreme Court, and Justice Kolawole, Owolabi Kolawole. They said, you are asking the court to stay execution. It's like asking the court to stay execution of the liberty of a citizen. That you are a contemnor. And being a contemnor, you are slapping us on the face by telling us to stay the execution. Do you know how they put it? He said it is like a sinner telling God that, look, God, I know I am sinning, but please help me, aid me to continue to sin. He said even God will not grant that sinner's request. He said in that same vein, we will not grant this request. This was the same court of appeal sitting in Lagos, and we are talking of as far back as 1992. What has changed? Ojukwu and Governor of Lagos State, it's clear. Governor of Lagos State versus Ojukwu, both the Court of Appeal and the Supreme Court, they made it clear that you can't be in contempt of a court procedure and come before us again asking for an equitable remedy, because stay of execution is an equitable remedy which is based solely on the discretion of the court. He who comes to equity must come with clean hands, and he who comes to equity must do equity. You have not done equity. You are coming with soiled hands. That was why the Supreme Court and Court of Appeal said, you have thrown Ojukwu out of his Velasca Lodge at Queen's Drive, Ikoyi. And we told you, take him back. You refuse to take him back, yet you are coming before us to ask for a stay of execution. We will not grant it. We have cited all these cases to show that even the point they were happy on, that Nnamdi Kanu jumped bail, we have shown through the exhibits that were attached. Nnamdi Kanu never jumped bail. He was granted bail and he was enjoying the bail. And the case was again to come up in October 2017. Then suddenly, like Fela will put it in one of his epic songs, the federal government through Operation Python on the 14th of September 2017 invaded ferociously with a multitude of army the ancestral home of Nnamdi Kanu, with his father Eze Kanu also there. In that brutal invasion, 28 unarmed and innocent Nigerians were hacked down in cold blood. We have put all of them. That was how Nnamdi Kanu managed to escape. A person escaping for his dear life cannot be said to be a person jumping bail. You jump bail when you voluntarily run away. But this was a man not running away, but not jumping bail, but running away for his dear life. And as soon as he got to Israel, he deposed an affidavit and reported the matter to the African Commission on Human and People's Rights, which wrote to the federal government. We executed it. Don't forget that on the 20th of July this year, the United Nations Working Group against arbitrary detention delivered the ruling after giving the federal government and the government of Kenya a fair hearing on the judicial rendition or an extraordinary rendition of Nnamdi Kanu on the 26th of June 2021, after he was accosted, blindfolded, brutally tortured on the 19th, between 19th and 26th, for about 8 good days in Kenya. A private jet was walking. They went around the security agency, the immigration. They didn't pass through. They forcefully rendered him back to Nigeria. And the law is that when you do that without going through extradition proceedings, you cannot try the person. At this court of appeal so far. The second one is what we call the doctrine of specialty, which this court also agree with, that even if Nnamdi Kanu were to be brought in properly through proper and lawful extradition proceedings, you can only try him for the offense you are bringing him back, not for any pre-existing offense, including the 5-count charge that was earlier existing, which they amended to 7 counts, which they later amended to 15 counts. For your information, the federal government has amended Nnamdi Kanu's charge 7 times because they have never been ready with prosecuting the matter. They are happy just keeping him. So this court said, you can't. You can't try him on those same charges. And the lower court was right. Justice Binta Nyako, she struck out 8 of the 50 counts. We were not satisfied. We came before this court, and this same court also struck out the remaining 7 counts and discharged Nnamdi. The Supreme Court has said that discharge in such a case also means acquittal. So Nnamdi Kanu has been acquitted. Because they can, like this court said, you can never try Nnamdi Kanu on those offenses before he ran away for his dear life. So what is it that will bring peace? Releasing Nnamdi Kanu. The medical doctors with DSSS, the federal government doctor, have no answer to Nnamdi Kanu's heart ailment. He suffers depleting potassium. All they will do at times, they come and increase dosage. They will lower the dosage. They are using Nnamdi Kanu, as we submitted today, as a guinea pig without knowing what is wrong with him. Now, they have refused a second opinion from a specialist doctor, as Justice Binta Nyako ordered. Now, you should allow a specialist doctor to come in. All the applications we have made to the DSS or the SSS to allow Nnamdi Kanu, they have rejected them. But the specialist doctor's opinion, we were able to get it, and we have attached it also as an exhibit, that if Nnamdi Kanu is not released immediately, he may die in their hands and in prison. If they want to know what will really cause brouhaha, ruckus, and wahala, it is keeping Nnamdi Kanu and allowing him to die, for example, in detention. Dead men don't stand trial. Sick men are even given medical treatment to ensure that they are fit and strong to stand trial. That is why we say, come and stand trial. Have you ever heard somebody say, come and sit down trial? Have you ever heard somebody say, come and prostrate trial? Have you ever heard somebody say, come and kneel down, or come and lie down trial? No, it is come and stand trial. It is taking that you are strong enough to be able to stand through that trial. So I am here begging the federal